Good morning, everyone. Welcome everyone to this interactive workshop. Let's see who are our participants. So, we have a mixed batch of participants. We have law students, and we also have faculties and deans from various law schools across the country. So, let's see. We have some from Northern Luzon, coming from the Visayas area, and coming from the Mindanao area. Welcome, everyone.
He- Yes, Francis. Good morning, everyone. For the 20 people here in the session, we welcome you. We're going to start in a few minutes. We hope you'd give us more of your patience today. Yeah, thank you so much for being here. Good morning, Miss Usodan. I hope I am pronouncing your surname correctly. Good morning, also, Miss Castro.
Good morning, everyone. Welcome to Within the Reach, an interactive workshop promoting the use of alternative dispute resolution in a legal aid organization.
We will be your presenter for today's program. My name is Yvette.
And I am Francis.
We are third year students of St. Louis University School of Law and officers of Chief Justice Manuel V. Moran Community Legal Assistance Office.
Today's interactive workshop will be focused on ADR, especially mediation and how it is conducted in legal aid clinics by law student practitioners like us.
Let us begin first by asking you, and you can message this in the chat. What do you know about mediation, or for better, on a scale of 1 to 10, 10 being the highest, gaano yung knowledge nyo when it comes to mediation? You can chat to your answers. 7.5, 8. How about the others? 7. It really ranges from 7 to 8, right? So that's why we are here. Francis?
So first, let us define what is mediation under the Republic Act number 9285 or the Alternative Dispute Resolution Act of 2004. Alternative dispute resolution refers to any process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency in which a neutral third party participates to assist in the resolution of issues.
Yes, Francis. Under Section 2 of RA 9285, the state promulgated this law to actively promote party autonomy in the resolution of disputes or the freedom of the party to make their own arrangement to resolve their dispute.
As law student practitioners, our main focus is on mediation, which was defined as a voluntary process in which a mediator, the law student practitioners, selected by the disputing parties, facilitates communication and negotiation and assists the parties in reaching a voluntary agreement regarding a dispute. However, it must be noted, as mentioned in the case of anonymous complaints against Honorable Dinah Evangeline B. Bandong, former presiding judge, Regional Trial Court, Branch 59, Lucena City, Quezon Province. Mediation of cases can only be done by individuals who possess the basic qualifications for the position, have undergone relevant trainings, seminars, workshops, and internship programs, and were duly accredited by the court as mediators.
Before an LSP may conduct a mediation proceeding, it is recommended that he or she has undergone training or workshop. That is why we are here. Rule 138-A gives LSPs the opportunity to assist and conduct mediation proceedings.
However, for the purposes of a mediation center established by legal aid clinics, there is no need for accreditation since the binding document between the parties is the mediation agreement and the mediated settlement agreement. Nevertheless, it is recommended that accreditation be sought after from the Office of Alternative Dispute Resolution Center of the Department of Justice. Accreditation of the center as an ADR provider organization, and the supervising lawyers either as a ADR practitioner or ADR neutral. As mentioned, the Supreme Court had promulgated Rule 138-A to prepare law students for the actual practice of law once they finish law school and pass the bar examinations. And of course, to ensure that there is an access to justice for all, most especially those in the marginalized sectors, including women, children, indigenous peoples, and members of the LGBTQIA community.
The Chief Justice Manuel V. Moran Community Dispute Legal Assistance Office, or the St. Louis University School of Law Legal Aid Office, focuses on rendering free legal services to the vulnerable sectors from the areas of Baguio and Benguet in northern Luzon. The CJMM CLAO is establishing and creating a community dispute resolution center for the members of the vulnerable sectors to be afforded an immediate relief without burning their finances by going to court. We, the presenters of this workshop, would also like to encourage not just our clients, but the LSPs and the lawyers to help on the promotion of out of court settlement remedies instead of the usual practice of going to court.
The Chief Justice Manuel V. Moran Legal Assistance Office group of LSPs created these community dispute resolution guidelines with the help of our Director, Attorney Victoria Dines, our Associate Dean Yasmin Lee Tadeo, and our Dean, Attorney Christine Angelica Elvenia.
To start off, when the LSPs were drafting this set of guidelines, our main basis were the Rule 138-A and the ADR Law of 2004. In the Rule 138-A, we have rules available for LSP2s, LSP1s, and the supervising lawyers.
In our guidelines, the roles that would be relevant in the mediation proceedings are the mediator, stenographers, and observers. For the mediator, only LSP2s are qualified to act or volunteer as one and to serve also as stenographers and observers. While for LSP1s, they are qualified only to act as stenographers and observers. Lastly, there must always be at least one supervising lawyer during the proceedings to observe, advise, and supervise the proceedings.
The primary role of the supervising lawyer is to observe the proceedings and to advise the student mediator and other LSP participants therein. However, if the need arises, he or she may also interject during the proceedings. Additionally, the supervising lawyer shall oversee all legal documents that are prepared during the proceedings.
Just like in any other alternative dispute resolution proceedings, all LSPs involved in the mediation proceedings should imbibe and exercise core values relevant to an ADR proceeding, such as integrity, neutrality, respect, and altruism. The mediator, stenographers, and observers, regardless whether LSP or supervising lawyer, should remain, act, and appear neutral to the parties. In regards to this, we included in our guidelines a penalty for disciplinary action for LSPs violating the requirement on neutrality and confidentiality. Aside from being subjected to disciplinary action, we also included that provisions of the university student handbook shall supply other appropriate penalties.
Because we value confidentiality as a part of the requirements on confidentiality. All informations or pieces of evidence to be gathered during the proceedings shall be kept in strict confidence and shall not be subject to proceedings in any quasi-judicial or judicial proceedings, except, however, when mutually consented by the parties, when it is made part of a public record, when asked and ordered by the court, and when it is necessary to prevent the commission of a crime.
Here, as shown in your screen, is the step-by-step process of our mediation. Firstly, there must always be the initial request for mediation by the parties involved. The LSPs and their supervising lawyers should have the opportunity to assess the case at hand. Once all of these are done, including the signing of a consent form and request for mediation, the mediation process will begin. Let us begin a detailed explanation of the process and the other details.
Prior to the start of the mediation proceedings proper, these things in your screen have to be explained to the parties that no use of foul languages shall be used during the proceedings with the purpose of keeping the proceedings civil and to keep emotions running high, or at least at a bare minimum. There shall also be an absolute prohibition against the presence of a counsel during the proceedings with the purpose of maximizing law student participation in the proceedings. However, again, this doesn't preclude either party to consult a lawyer to attending a session of the mediation proceedings. Lastly, short breaks may be declared during each session either upon the motion of the parties or upon the initiative of the student mediator.
When accepting requests for mediation, we classify them into two kinds: voluntary mediation and mediation through referrals. When we say voluntary mediation, it might be the case that either one of the parties or both parties voluntarily ask the center to conduct mediation proceedings between the two. In both instances, an invitation to a mediation conference shall be sent to the parties. If it were a mediation through referrals, the request for mediation was forwarded either from the barangay after failing therein through barangay conciliation proceedings or from any other third party who referred the case to the center. Hence, it is important to have a good working relationship with the communities to which your legal clinic has jurisdiction of.
In assessing the case, one has to determine whether the issue is a mediatable case only upon a determination of such that an invitation for a conference meeting shall be sent to the parties. If it is not, then such request for mediation should be respectfully declined upon.
Moving forward with the process, the next part of the mediation is the introduction, where the mediator can introduce himself and the other participants in the proceedings. This is also a good opportunity to build rapport with each party by initiating small talk. After all the explanation, it is in this part that certain documents should also be accomplished by the parties. The first one is the consent form that would indicate their accession to the proceedings, as well as a data privacy form for the confidentiality of the proceeding.
After the introduction, an opening statement by the mediator shall be made stating therein the outline of the proceeding and to orient the parties as to the parts of the mediation. This portion is also an opportune moment when the mediator can ask clarificatory questions. Again, the mediator can ask clarificatory questions or even probing questions to the party to determine further the nature of the case or otherwise discover facts and circumstances which may cause a conflict of interest, provided that these facts and circumstances were not discovered or were not disclosed to the center staff prior to the proceeding.
Afterwards, each party shall be given equal opportunity to narrate their versions of facts. Likewise, during the opening statement by the mediator may once again ask probing questions to clarify or supply missing facts from each narration. All of this shall then be summarized by the mediator, discarding irrelevant facts while including important facts and issues.
After the narration of facts and its summary, the most important part of the mediation proceedings comes to pass. During this portion, the mediator should guide and lead the parties to explore and come up with suggestions that may have on how to reduce their grievances. The mediator should see to it that whatever remedies being considered by the parties should be number one, realistic. Number two, because we're all law students and law deans here, legal. And number three, achievable by the parties.
It may also be the case that when there are obstacles to an effective negotiation between the parties, then the mediator may conduct private sessions with each party behind closed doors to extract or at least alleviate them and to have them successfully accede to the negotiations. The key principle here is that there should always be an equal opportunity given to each party for such private sessions unless expressly waived by the party.
Yes, when the parties are amenable and have willingly agreed to their demands, concessions, or whatever agreements they made, they shall put those in writing in the form of a mediated settlement agreement assisted by the mediator. This mediated settlement agreement will be binding to both parties. However, the parties may still opt to have their settlement agreement deposited with the regional trial court in accordance with the provisions of the ADR law of 2004. If either party will not fulfill their obligation in the agreement, the aggrieved party may seek execution and enforcement of the settlement agreement with the court.
However, we accept the reality that not all mediation proceedings are successful. There might be cases of failed mediation caused by sudden withdrawals of either party. There could also be failure to meet or agree in an amicable settlement agreement, or there might be sudden changes of circumstances causing such failure.
We
In these instances, either party may seek the issuance of a certificate attesting to such failure of mediation.
We can summarize the whole mediation process into these parts. First is the assessment, introduction, summary, generation and evaluation of options, closing, and post mediation proceedings. The crucial portion of the process is the assessment of the case. In this part, the student head, upon supervision of the director of the legal aid clinic, may see to it that the case is a matter that can be proper subject of a mediation proceedings. This would then be followed by other parts of the process.
Parties and the mediator must be formally introduced. There must be a summary of the issues presented by the parties. The mediator will then evaluate the options based on the presentation of the issues. Once the parties have agreed on settling their dispute, they, with the help of the mediator, will draft a mediation agreement, after which there will be an execution of the agreement and the closure of the dispute. Furthermore, the center will proceed to discuss post mediation remedies and processes to the parties.
Moving on to other matters, to stay true to the purpose of a legal aid clinic, no service fee shall be demanded from the party seeking mediation proceedings from the center. Consequently, no gifts nor present or any form should be accepted, since this would also tarnish the reputation of the center as well as cause suspicious to the as to the neutrality of the participants to the mediation.
To further reinforce the competence of the our LSPs of the center, training and seminars from other ADR organizations or from government agencies shall also be sought for. The center likewise shall also conduct training, seminars, webinars, and other forms of awareness campaigns in order to disseminate information for mediation as an ADR and even alternative to court litigation. This can also be achieved by having a good relationships with our barangays and communities by executing memorandum of agreements with them.
Lastly, the guidelines are deemed to have subsumed existing laws, rules, and regulations which are applicable and appropriate with mediation.
Now that we have an overview and a detailed explanation of how mediation proceedings in our legal aid clinic works, let's put your knowledge to a test.
Kung kasama kayo kahapon, let's start strengthening the pumpkins. We will be flashing 5 case problems with 4 possible answers on each problem on your screen. You may choose the best solution based on the community dispute resolution we discussed earlier. There will also be a few questions regarding mediation rules as provided for under Rule 9285 and the special ADR rules. We will give you 10 seconds to pick your answer from the poll. Afterwards, we will have a short discussion on the answers.
So let's start with a practice round. Sample question: what is mediation? Our choices is letter A. It is an adjustment and settlement of a dispute in a friendly and an antagonistic manner through extrajudicial means, bringing two opposing sides together to reach a compromise in an attempt to avoid taking a case to trial. Letter B. It is an ADR process wherein the parties and the lawyers are brought together to present summaries of their cases and receive a non-binding assessment by an experienced neutral person with expertise in the subject or in the substance of the dispute. Early neutral evaluation is availed in the early pre-trial phase. Our choice letter C, it is a voluntary process in which a mediator selected by the disputing parties facilitates communication and negotiation and assists the parties in reaching a voluntary agreement regarding a dispute. And letter D, it is a structured dispute resolution method in which the merits of the case are argued before a panel composed of senior decision makers with the presence of a neutral third person, after which the parties seek a negotiated settlement. So let me publish our poll. You can choose your answers now. It's a sample round. There's
No pressure, guys. No pressure. This is not graded. This is like recitation, but we won't grade you.
okay, so we have 3 votes. So let's see. So our the correct answer there is letter C, which is it is a voluntary process in which a mediator selected by the disputing parties facilitates communication and negotiation and assists the parties in reaching a voluntary agreement regarding a dispute.
Yes. Oh, we have. Gosh, we can't read the choices. Oh my. Oh, okay. Don't worry, guys. During the sample round, hindi talaga namin nalagay yung choices. But during the game proper, there would be choices. We will give you options. Don't worry, guys. Now we will start. Are you all ready? I hope you're all ready and that you listened to us earlier. All answers were discussed earlier. So, now, the first problem involves a demand for sum of money. This is the problem. Diego and Eugene are neighbors in Barangay ABC. Diego was locally known as a loan shark. His transactions were always put into writing, witnessed, and signed by the parties but were not notarized. In one unfortunate circumstance, the daughter of Eugene got sick, which caused Eugene to immediately take her to the hospital and pay for medical costs. Diego, having heard of the situation, voluntarily lent Eugene an amount of 50,000 pesos. He had forgone the formalities of putting the loan into writing due to an emergency situation. Sobrang bait naman ni Eugene. After a few months, Diego asked Eugene for the payment, which Eugene replied by asking for an extension. On due date, Diego came again demanding from Eugene his payment. It was at this moment that Diego had used foul language, to which Eugene readily replied in a likewise manner. The first question is, which of the various forms of ADR would be best for the parties to enter into? Our choices: letter A, mediation proceedings or community dispute resolution. Letter B, arbitration. Letter C, mini trial. Or letter D, none. The parties must go straight to court litigation. We will give you 10 seconds to answer. Sorry, wait. Francis, are you ready for the poll?
Yeah, the poll is already up.
Okay, you have 10 seconds to key in your answer. Have 10, 9, 8, 7, 6, 5, 4, 3, 2, and 1. I hope you already have your answers. Francis, what is the answer?
So the correct answer here is, of course, mediation or yeah, mediation. Letter A, mediation proceeding or community dispute resolution. We have to understand that they both belong to a barangay, so logically they would go through the process of having their complaint before the lupon. After that, in case the lupon would fail to conciliate the two, then it might be referred to the center. However, again, since this is mediation, the parties should voluntarily and willingly forward their case to the center. So
Francis, we have a technical difficulty. Our participants are saying that they don't see the poll, unlike the sample problem from earlier.
Let's hoping the next poll would be visible to them.
Okay, okay, okay.
Okay, so moving on now, since we have limited time, our next question is a general question.
Wait, Francis, for the second question on the same problem. After the parties consented in a community dispute resolution, a newly accredited LSP1 asked his supervising lawyer if he can be the one to mediate the dispute because he personally knew the parties as he is also a resident in barangay ABC. As the director of your legal aid clinic, what will be your answer? Is it A, I will grant the request of LSP1 because he is qualified to conduct the mediation proceeding? Or letter B, I will not grant the request of the LSP1 because only LSP2s are qualified to conduct mediation proceedings. While letter C is I will not grant the request because there might be impartiality and a conflict of interest on the part of the LSP1 as he is personally connected to both parties. While letter D is I will grant the request of the LSP1 provided that both Diego and Eugene will give their consent to having him as their mediator. Francis?
So let me post the poll already, hoping this would be. Can you see participants? Hoping you can see it.
Can you type on the chat box none? Wait. Sorry for
Yeah. So the votes are coming in. Okay, good. So we have some saying letter B, some saying letter D. So let's. It seems no votes would be coming in. Oh, they're still okay. Okay, good. So 10 seconds is already up. Let me close the poll. So the correct, not really the correct answer, but the best answer here is letter C. I will not grant the request because there might be impartiality and a conflict of interest on the part of the LSP1 as he is personally connected to both parties. However, letter A may also be a good answer since in our guidelines, we posited therein that LSP1s cannot become mediators. However, the best answer here is letter C. I will not grant the request because there might be impartiality and conflict of interest on the part of the LSP1 as he's personally connected to both parties. Since they all belong to the same barangays, the best course of action here is to pick a mediator who is really not connected or is stranger to both parties. So we avoid any doubt or shade of having the neutrality of the center questioned.
We would also like to include that because this guidelines, the CJMM cloud guideline, is actually in a way synchronous to the St. Louis University School of Law curriculum. The LSP2s are the only ones allowed to conduct mediation proceedings as they are more equipped to handle these types of cases. Because on in the SOL curriculum or the old curriculum that we are using, me and Francis as third year law students, ADR is a subject taken up during the second year, second semester. Hence, most LSP ones are presumably haven't taken the ADR subject yet or is still currently taking the ADR, unlike LSP2s that have already finished the course. So I hope that your answers were correct. We are tallying it now. Francis, for our second question.
So our next question is a general question. Which of the following is not an advantage of mediation? For number one, confidentiality in the mediation process. Number two, prompt, economical, and amicable resolution of the disputes. Number three, decision-making authority rests in the chosen mediator. And number four, the parties has the liberty to create their own settlement. Let me publish our poll. So there. Which of the following is not an advantage of mediation? Okay, good. Waiting for other responses. Okay, nice. So let me close the poll right now. We have 9 votes. So you are all correct. The correct answer there is number 3. The decision-making authority rests in the chosen mediator. This is really not an advantage of mediation, since we have to remember in the mediation as an LSP2 mediator, our main role there is to assist the parties, to facilitate good communication, to make the parties amenable to settlement. The negotiation, the solutions, the remedies, they themselves should initiate that. What you would do is to make sure that those decisions are realistic, legal, and possible within their reach.
Yes, thank you, Francis, and thank you everyone for participating. We're not done yet, don't worry. For the second case problem, this involves a recovery of possession of real property. Jungkook, owner of a two-story house in the heart of Baguio City, leased the said property to Taeyong. They made a lease contract available until October 31, 2022. On December 2, 2022, Jungkook went to you to ask for your help as Taeyong has refused to return the property to him. Taeyong's contention was that he already paid the rent for the month of December and that the reason why Jungkook was pressuring him to return the property was because the latter sold the property to Yoongi. Jungkook went to your legal aid clinic to ask to mediate their problem. However, Taeyong refuses to be part of the mediation. How will you resolve this? For our choices, letter A. The mediator shall continue with the mediation proceedings even though Taeyong refuses because one of the party insisted. Or letter B. As a mediator, you shall refrain from doing anything as you cannot start the proceedings without the consent of all parties. Or letter C. The mediator may start the proceeding by discussing to Taeyong the importance of mediation and how will this help both parties. Or letter D. The mediator shall refer the case to the court. Francis, for the poll.
Okay, let me publish our poll. Okay, lock in your answers now.
I hope everyone's answers are locked in. Francis, let's close the poll.
Okay, let me close the poll.
The answer to the question is letter B. As a mediator, you shall refrain from doing anything as you cannot start the proceedings without the consent of all parties. The aim of a mediation proceeding is for parties to settle their dispute by coming up with a written agreement which they both expressly agreed upon and made upon. Consent is the key point to all of this. Without consent of one party, there can be no mediation to begin with. Hence, mediation proceedings cannot start without the consent of both parties. Additionally, mediators cannot interject any personal opinion or expression or any matter at any stage of the proceeding unless the parties expressly ask to. But again, guys, this is an exceptional circumstance. I hope you understand that. For our next, the third case problem.
So, our third case problem involves a demand for support. Anton and Jazz were in a relationship for 2 years when they had a child together. Thereafter, Jazz left Anton after finding out that the latter was actually married to Andrea, her best friend. However, Anton told her that even though they broke up, he will still provide for their child. 5 years later, Anton never gave a cent. Just came to your legal aid clinic to seek advice regarding financial support. The parties then proceeded with the mediation and came to a resolution that Anton shall give one fourth of his salary. After the mediation, Just insisted on giving you 10,000 pesos as a thank you bonus. As a mediator, what should you do? Uh, so our choices is letter A, I will accept the amount because it is not a fee, but a thank you bonus for my hard work. Letter B, I will not accept the 10,000 pesos but will ask the party to give me an in-kind bonus instead. Letter C, I will accept the amount but I will deposit it to the funds of the legal aid clinic. And letter D, I will not accept the amount because the legal aid clinic does not collect any kind of fee. So the poll is now open. Lock in your answers now. You all have 10 seconds to lock in your answers. The best answer. Go. Okay, we have 4 votes, 5 votes. Okay, so no votes will be coming in right now. It seems only 6 voted. So let me close the poll. So the best answer there is you're all correct. It's letter D. I will not accept the amount because the legal aid clinic does not collect any kind of fee. As a policy and stated in our guidelines, and as to the since it is the nature of a legal aid clinic that our services are free since we cater to the marginalized and to the underprivileged. Moreover, even though the mediation proceedings have been successfully disposed of, it is imprudent and reckless to accept any kind of fees, donations, presents, gifts of any kind. We have to preserve the integrity of the center as well as the integrity of the LSPs and also its neutrality. So moving on forward to our next question. Our next question is a general question. Which of the following problems cannot be the subject of an amicable settlement? Number one, a complaint filed against TOTEP. Number one or letter A for drug trafficking. Number two or letter B, land dispute involving Alex and ABC International Corporation. Letter C or number three, illegal dismissal complaint filed by James against his employer Jermaine. And lastly, complaint for sum of money filed by Vaughn living in Barangay ABC against Kim living in Barangay DEF, whereas the parties agreed to settle in Kim's jurisdiction. So let me post the poll there, which is not the cannot be the subject of an amicable settlement. Okay, it seems number one letter A, number and letter B were the choices voted upon. So let me close the poll right now. So the so the best answer though is letter B. However, it is true also that number one is also not is cannot be also the subject of an amicable settlement since it's a criminal case. Um, uh, it cannot. It's straight to the courts. However, according to the Supreme Court Administrative Circular Number 1493 dated July 15, 1993, number two or letter B could also be the answer since it is also prohibited. So, as an exception, also, the civil aspects of a criminal case can also be the subject of an amicable settlement. Okay, so moving on.
Yes, Francis. To reiterate, yes, a complaint filed against Totep for drug trafficking is also cannot be a subject of an amicable settlement. And also the answer on your screen, the land dispute involving Alex and ABC International Corporation. So let's go to our fourth case problem. It involves unjust fixation. Pete, the barangay captain of Barangay Crimson Katipunan, came to the legal aid clinic to endorse a problem they encountered in their barangay. Apparently, a wealthy man named Vegas kept on disturbing and harassing some of their constituents whenever he was drunk. Pete had received numerous complaints. However, due to unforeseen circumstances, the barangay couldn't handle the situation. Both parties came to your legal aid clinic. Pete was alone, but Vegas was accompanied by his group of lawyers. Pete got intimidated by the lawyers, so he asked if Vegas's lawyers would not be permitted to enter the mediation room. Let's resolve the case. Your choices are letter A. The mediation will still proceed. The parties are allowed to seek legal advice from their lawyers. However, lawyers shall not be permitted to enter the mediation room. Or letter B. You must dismiss the whole case. Lawyers are not permitted to be involved at any stage in the mediation proceedings. Or letter C. The mediation will still proceed. Vegas's lawyers will be allowed to enter the mediation room provided that they will not speak all throughout the proceedings. Or letter D, the mediator must ask both parties for consent if they will allow lawyers to be part of the mediation proceedings. The poll is up. You have 10 seconds to answer the poll. Thank you so much for answering our poll, guys, and for actively participating. You have 10 seconds. Francis, can we close the poll now? The answer is letter A. The mediation will still proceed. The parties are allowed to seek legal advice from their lawyers. However, lawyers shall not be permitted to enter the mediation room. Under the CJMM CLOW guidelines or the Community Dispute Resolution guidelines, lawyers of the parties are prohibited to attend the mediation proceedings. However, in the interest of justice, parties may opt to seek assistance from their counsel prior to attending the mediation proceedings. Hence, in that case, Vegas is allowed to seek advice from his pool of lawyers, but Pete was also right that the lawyers of Vegas may be or must be prohibited to enter the mediation room. Our next last case problem, Francis.
So our last case problem involves a cyber libel case. Vicky Bellio filed a libel case against Hart Evangelist. Vicky claimed that Hart posted in her social media that Vicky snubbed her during a fashion show event and that Vicky was maldita and ugaling artista kahit hindi naman sikat, which made Vicky lose her skincare endorsement. Hart went to your legal aid clinic to seek advice. What would be your remedy? So our choices are letter A. I will ask both parties to sign the consent form before proceeding with the mediation proper. Letter B, I will inform the parties that the mediation cannot proceed because the issue is not one which can be a subject of a community dispute resolution. Letter C, as a mediator, I will advise both Hart and Vicky to proceed with court litigation. And letter D, the mediation proceedings shall begin, but I shall first send the parties notices of conference. So, kindly lock in your answers now. Okay. Hmm. So we have 8 votes as of now. Let me close the poll. So two people got the best answer. It is letter B. I will inform the parties that the mediation cannot proceed because the issue is not one which can be a subject of a community dispute resolution. In this case, it is a cyber libel case, so it's a criminal case. So obviously, it's not a cannot be mediated upon. Moreover, it would be quite difficult and dangerous, especially if the parties are emotionally unstable or not amenable to mediation itself. Okay, so moving on to our last and bonus question, Yvette.
For our bonus rounds, we will change the game mechanics in a konting-konti lang naman. In this part, there would be no poll, and we will try to exercise our skills to mediate a proceedings. You will type in your answer in our chat box. The problem is this involves uno, two, third, four, and cinco. They are the children of Travis and Althea. 6 years ago, both Travis and Althea died of car crash intestate. Until now, their properties haven't been partitioned due to the lack of participation from all siblings. Third insisted that he must have a bigger share of the estate as he was the one who took care of the funeral, while Uno claimed that being the panganay, he is entitled to their childhood home. Two and four didn't care much about the inheritance but claimed that Cinco should get a lesser share as he is only a bunso. All siblings voluntarily agreed to a mediation proceeding and expressly asked you as a mediator to resolve their case for them. As a mediator, what will be your resolution? We will give you 15 seconds to type in your answer for what would be your suggestion in this case.
Don't be pressured. There are no wrong answers here, but there could be best answers.
Yes. Again, there's no right and wrong. There's always right. We're always right. Is it hard, guys? I hope that you're typing in your answer. Um, While you're typing in your answers, we will give you a suggested answer, or our Francis and I suggested answer. Okay, our answer is, as a mediator, as a general rule, I am precluded from resolving the issues of the siblings. As earlier discussed, the parties are the only persons who are entitled to resolve their dispute. Mediators must refrain from giving legal advice or engage in counseling, nor can mediator express his or her personal opinion. However, in this case, the parties expressly requested an evaluation of the case. Hence, our advice is to, of course, partition the property equally within themselves. We have one answer from Ms. Usodan. As a mediator, I have no authority to resolve the case for them. The parties are the ones who will be providing their decision as they agreed upon. That's correct, Ms. Usodan. Yes, as we discussed earlier from our CJMM Cloud guidelines and also under the ADR rules of 2004, the mediators really cannot resolve the issues for them. They can only do it or partially do it if the parties would expressly say na we want you to resolve the case for us because we don't know how to, but that should be expressly agreed upon. Again, guys, in under the mediation, consent is the key point of all of this. There's always a need for consent from both parties. Even if one party would say that the mediator may resolve it, but the other doesn't want to, the mediator cannot or must refrain from expressing his own opinion. That's it, Francis.
So before we officially end with this interactive workshop, we will already be entertaining any questions, or may we ask our participants any thoughts about the workshop, about mediation as a tool of training our LSPs for future practice? Any thoughts, questions?
While waiting for that, let me read the chat of Miss Katrina Lucena. I will frankly say that under PH law, the order of birth is not determinative of their shares in the inheritance. However, I shall emphasize that since the same was requested, I will answer the question. That's right. Porket bunso, grabe. Sure. Let's read this message from Miss Maria Isabel Gonzalez. Given that the mediator cannot influence the agreement of the parties, how will the mediator ensure the rule of law is being upheld in this ADR modality? Francis, do you want to answer this?
Um, Basically, in an ADR, consent of the parties is essential. Hence, you have before official or the proper mediation proceedings will proceed, the mediator should explain in a detailed manner to the parties what to expect, what are the prohibited manner conduct during the proceedings, and that the success or failure of the mediation rests between themselves. So we have to remember that as ADR providers, we don't have any compelling authority, unlike the courts. So in actuality, what we send to the parties themselves is named as invitation. It's not really summons, but an invitation to a mediation proceeding. So basically, we as mediators and as facilitators of mediation itself, we should strike and when they are already bordering to violations of rule of law, we have to confront them there and then in a respectful and a convincing manner, um, to guide the parties to a more better solution or manner of resolving their dispute.
To add to Francis, what Francis said earlier, we earlier also discussed that even though we really cannot influence on the agreed or the agreement of the parties, the mediator is responsible to tell the parties or to make sure that the agreement of the parties is again legal, of course, that it is amenable for both parties, and that there isn't no fraud influencing the agreement. So we can still say something. It's just that we cannot really or agree for them, or we cannot say our or express our opinion. But of course, if you see something that's parang the agreement is kind of, you know, isn't amenable, or you can say something. You can say something. It's not naman prohibited. We can still talk.
Other thoughts?
Are there any more questions or message for us? I think we'll give 15 seconds. If there would be no question after 15 seconds, then we will wrap it up already.
As an additional, just in case you are interested to take a look at our guidelines, we can share them to you, but please kindly send in or chat in your email address or any communication for that matter so that we can send to you right after this if you are interested to look at it. Okay, so some have sent their communication. So let's end. So we encourage everyone here, most especially LSPs, supervising lawyers, and deans of various law schools to create your own mediation or community dispute resolution guidelines to help you facilitate mediation in your respective legal aid clinics. You may use the CJAM Cloud guidelines in designing your very own framework of ADR practices that your law schools or legal aid clinics may adopt to increase the relevance of facilitating ADR in your respective areas.
This is the intention of Within the Reach. We want to give the public a more accessible justice system by promoting alternative dispute resolution processes, which are, again, within their reach.
Thank you all for participating in Within the Reach interactive workshop. We hope that you picked up few knowledge in mediation and of course had fun.
As John F. Kennedy once said, let us never negotiate out of fear, but let us never fear to negotiate. As lawyers and future lawyers, and as law student practitioners, we must promote out of court remedies to our clients, encourage the parties to an amicable settlement in their dispute, or to reach a compromise agreement to avoid lengthy and costly litigation. Again, my name is Yvette.
And I am Francis. Again, we are from the St. Louis University School of Law and the Chief Justice Manuel V. Moran Community Legal Assistance Office Community Dispute Resolution Center. Thank you and stay safe.
Thank you, everyone. I hope you enjoyed.